Didomenico.
Good morning, Your Honors.
Good morning, Mr. Booten.
Brandon Booten and Charles Ward here on behalf of the appellant, Mr. Didomenico. Before I start, I'd like to reserve 5 minutes for rebuttal.
5 minutes, certainly.
Yes, Your Honor. May it please the court, Appellee's brief in this case starts out with the aphorism, and I'm paraphrasing here, but it starts out with the aphorism of, when you're weak on the facts, you pound the law. When you're weak on the law, you pound the facts. When you're weak on both, you pound the table. And then it adds the statement of, in this case, the appellant is choosing to pound the trial judge. Well, that conveniently ignores the fact that in this case, both the facts and the law are on the side of the appellant. This case emanates from a 3-day divorce trial in Williamson County. And after that divorce trial was completed, a voluminous transcript of the record was produced, as one would expect after a 3-day trial. And I encourage the court in this matter to fully examine the transcript and the record of this case when making its decision. Because while there are many examples in the briefs of the instances that were laid out of the behaviors of the trial judge, there's no way that all the instances can be laid out in a 15,000 word limit brief. So I'd ask the court to review the entire record. In this case, appellant is challenging the ruling of the trial court, asking for the court to remand the case for a new trial because it's the position of the appellant that the trial judge in this case should have recused himself. And replete throughout the transcript are at least 50 instances of the trial judge acting disparately to the parties in this case, interrupting, interjecting, arguing, rebuking, criticizing, expressing frustration, expressing dissatisfaction, and otherwise frustrating a husband's ability to put on proof in this case.
Well, a lot of the judge's interruptions were trying to clarify what was going on, were they not?
Well, I think that's true of the mother's or the wife's testimony. I think certainly if you review the transcript and you review the colloquy between the court and the witness, certainly the court's questions and interruptions to the mother were of clarifying nature. But if you read,
did not the judge complain that father's answers were confusing him and he was trying to understand what was going on and you know, amidst all the rambling, he couldn't figure out what the answers were?
he did say that, and he self-referenced the fact that he used to be a trial lawyer for many years, and he had set expectations of how witnesses should answer questions. And the fact that the husband wasn't answering the questions in regard to his expectations was where he was asking the questions. But I'll submit to the court that just because the husband wasn't answering questions in the way that the judge liked doesn't mean that he wasn't answering the questions.
No, but I got the impression the judge was not able to understand what the answers really were, and that was a source of frustration and a source of the questioning.
I think it was a source of the questioning. I think I would disagree with the characterization that the judge was completely confused about the husband's answers. If you look at the colloquy of answers and questions between the husband and the court, there were so many instances where the court would interject without objection by opposing counsel and would instruct the witness to answer a question, particularly in the way that the judge wanted him to answer. But again, people answer questions differently. People testify differently. Some people will give you just a one-word answer, and some people will give you the whole background experience as to why they got to that answer.
Well, and some people don't answer the question at all. And I think that's the problem that potentially we had in this case, was the judge seemed to me to be expressing frustration with husband's inability to just answer the direct question.
I think it's a fair characterization of what happened, but I still submit to the court that because the husband was giving an answer that the court necessarily didn't understand, he was still answering the question. The husband wasn't trying to be obtuse or be defiant of the court. That was just the way that the husband answered questions. Now, whether the court took it that way or whether the court was confused by the answers, in the husband's mind, he still answered the questions that were asked to him.
Well, ultimately, though, the court made some credibility determinations and said, husband's testimony was difficult. Basically, I found that he was evasive, and he made some other findings that basically suggested that he didn't find husband's answers to be completely credible. And that certainly is within the court's purview to make that finding. We want trial courts to make findings either way.
We do.
Yeah.
But the way the court acted disparately to the husband as opposed to the wife, the court, when the wife was putting on proof, the court found one of the wife's witnesses to be credible before she was even cross-examined. And quite frankly, I would expect a witness to be credible on direct examination without being cross-examined. Otherwise, I don't know why that witness would be called. So it's those types of actions that are being called into question here. Again, it's not just one statement here or one statement there. It's the totality of the actions of the trial court in this case that I want the court to examine when they're making this decision. Because again, you have that statement with the wife's witness. You have the statement to the wife about trying to clarify her answers and give non-conclusory statements, but give evidence as to what she's talking about. But when he questions the husband, and again, most of his questions to the husband were without objection by opposing counsel. When he questions the husband, he accuses the husband of being evasive and not answering the question. And again, just because the trial court didn't understand the answer doesn't necessarily mean that the husband was being evasive. And so I'm asking the court to consider all of that when they're making this determination in this case. Because again, the actions of the trial court are so egregious in this matter that the question is, if a person of ordinary prudence in the judge's position, knowing all the facts known to the judge, would find a reasonable basis for questioning the judge's impartiality, then a recusal is required. Doesn't even have to show actual bias, it's just a perception of bias. And if you look at all of the actions of the trial judge in this matter, certainly the perception of bias, the question of is there a reasonable basis to question the judge's impartiality is present in this case. And because there was no recusal in this case, we are asking this court to remand for a new trial because the trial judge should have recused himself once it became evident that there was a possibility of questioning his impartiality.
Where did his alleged lack of impartiality come from?
I don't know. That's a question for the judge.
Well, it came from his answers. It came from what was happening in court. Is that correct?
I would not characterize it that way.
Oh, so it came from something outside of court.
I think.
Well, have you alleged that there was anything outside of the court that made the judge biased against this person?
Again, actual bias is not required, but the perception of bias is.
Well, you claim that it takes that if someone just looks at this, that it's a bias, it's a perception of bias. But if the perception comes from what's going on in court and the judge's frustration with vague answers and perhaps evasion comes from that, then that's not a real grounds, is it?
Not by itself. But the fact of this matter is the judge in this case actively frustrated husband's ability to put on proof. There were areas that were explored during wife's direct examination regarding claims of this divorce, claims of alimony, claims of child support, claims of the parenting plan. When those questions were tried to be delved into on cross-examination by the husband's counsel, the court said, I don't care about that. I don't want to hear about that. I don't know why this is important here. And so it's that type of action, along with the questioning of the witness, along with the questioning not in opposition to objections from counsel. All of it in totality shows the egregiousness of the trial judge in this case. And the fact that the husband was basically frustrated himself from putting on proof in this matter because he couldn't cross-examine effectively about issues of alimony, even though the wife was allowed to explore those issues on direct examination. He couldn't give the answers that the judge was looking for, even though he tried to answer the questions. Now, whether he was being evasive or not is certainly a question, I guess, for the trial court. But to all of this in conjunction with each other, the fact that the judge bolstered the credibility of the one witness who hadn't even been crossed yet, all of this in consideration with each other shows the bias or the perception of bias for the judge in this case. And that's why we're asking the court to remand for a new trial. Certainly, I understand vagueness or the insufficiency of the husband's answers to the trial court. But it's not just those things. It's all of it in total should be looked at by the court when making this decision. The court, again, if this trial had proceeded as normal, if the attorneys had been allowed to be attorneys and the judge be the judge, if the questions that the judge posed to the husband were asked by opposing counsel or objected to by opposing counsel, direct counsel could have responded to the objections. He could have rephrased the question to see if the question's a better question. But because the judge in this case was asking these questions, basically making objections without making objections, there's no effective way for the direct counsel, for husband's counsel, to combat those objections that are being made. The judge asked
Couldn't the attorney rephrase some of the questions to try and get a more direct answer?
I suppose he could have, but at the point where the judge is interrupting the husband's counsel all the time or throughout the trial, at some point it just becomes an exercise in futility. If the trial judge is interrupting the court and asking the husband questions without objection from opposing counsel, direct counsel has no way to rephrase the question, has no way to argue against the objections because they're being made by the judge themselves. And so with all of these things considered, we're asking the court to remand for a new trial. Thank you.
Thank you. We'll hear from the appellee. Good morning, Mr. Manis.
Good morning, Judge, court, members of the court. May it please the court, I'm Roger Manis. I'm the lawyer representing the wife in this appeal. I'm pleased to have with me today my colleague, Colleen Hyder, who assisted me in the trial of this case. She's here to observe. So this case was filed back in March of 21. It's now 4.5 years old. By the time we got to trial, it was fully over 2 years old. Quite a bit had gone on in the intervening 2 years. Judge Woodruff had the case for the first really 2 years of the case, and then to my surprise in early 2023, because he had the criminal side of the indictment of Mr. Didomenico in the matter, announced on a motion hearing one day that he was going to transfer responsibility for the civil case, the divorce case, to Judge Binkley. So that's how we got to where we are in the matter. Counsel, I did inject a humorous aphorism, I thought, at the beginning of my brief, and pointed out that being unable to avail himself of the facts of the law, he elected to pound the trial judge in this case. Now, counsel responds this morning by saying both the facts and the law are in favor of the applicant, of the appellant, rather. Now, that opens the door to this rhetorical question. If that's the case, then why was no issue presented for review on appeal challenging any finding of fact by the trial court or any conclusion of law by the trial court? There were none. Now, in their reply brief in this matter, they focus on the fact that I had in my brief of Appellee pointed out that no effort was made along the way to address any of these matters about which are complained in this appeal. And they say, well, you know, there's no requirement for that there are cases in Tennessee, and certainly there are extraordinary cases where appellate courts have said the trial court should have recused himself or herself sua sponte. Now, those are extraordinary cases, frankly, and most of those cases, I think, involve post-conviction relief matters in which the trial court expresses essentially that he's prejudged the matter before any proof is heard on the post-conviction relief petition. Another case, I think, involves a point where a trial judge says he wouldn't believe a witness, and he's throwing an affidavit out. Well, obviously, an affidavit is not a witness testifying in court whose demeanor can be observed. We got to trial in this matter. For the first time, I had worked with Mr. Dimick and Miss Gilliland in this matter. Became very fond of them in the course of this thing, and I thought they did a very good job aggressively representing Mr. Didomenico with a very difficult set of facts. The court can read my statement of facts, which is much more abbreviated than Judge Binkley's findings of fact, 70 pages of findings of fact, and see that this case involved very, very egregious behavior by the husband in it. And so that carried over, frankly, into the trial. We can admonish witnesses as trial lawyers. I've tried several hundred cases in my career, and we always admonish witnesses to answer, our witnesses at least, to answer questions concisely. If it's a yes or no question, lead with a yes or no in response to the question, and then if you need to explain, give the explanation. But frankly, some witnesses are just hard to keep on the porch, and that was Mr. Didomenico in this case. His lawyers worked hard to keep him on track, but he simply would not be kept on track in his answers to questions in this case. Now, what the record cannot reflect and what counsel cannot know because he was not there is that I was wearing out a pair of pants standing up to object, and more often than not, Judge Binkley would, at this point, would anticipate my objection and take over in the examination himself and admonish the witness repeatedly over and over again to answer the questions. So the reason it's important in this case that we ought not allow this kind of strategic use of a motion to recuse the trial court at this point is that every fact about which they complain, every comment by the trial court about which they complain was known at 6 p.m. on June 30th, 2023 to counsel that were then representing Mr. Didomenico. After that, based on the instruction of the court, we both worked for 3 months submitting proposed findings of fact and conclusions of law. There were several, in addition to that, several post-trial motions that were filed, prepared, briefed, argued, trips back and forth to Franklin, and tens of thousands of dollars were incurred in attorney's fees after the fact, after the conclusion of the trial on June 30th, without anybody uttering a word about Judge Binkley being required to have recused himself sua sponte in this matter. So that's why it's important in this case that they failed to raise this issue in a timely way, even if they, and in my mind, it would have been untimely even then, probably would have been inappropriate from a substantive standpoint. I've pointed out in my brief, I've cited 3 long quotes from Court of Appeals opinions on page 47 of my brief, and they correlate with Judge Bennett's questions to appellate counsel earlier. The type of matters that involve a trial court to recuse himself or herself sua sponte are not matters that occur within the trial. As we all know, all judges are different. Some take a very proactive role in the trial of cases, and some sit there like a stone statue. I've had Judge Morton on the federal court bench admonish me for using my hands too much, standing at the podium. He didn't like anything other than questions and answers, and if you waved your hands too much, you heard about it. So I've had Chancellor Gray sit up on the bench and not utter a word for all day long, and you'd have to beg him to take a bathroom break. So judges run trials differently, and Judge Binkley had set this case for 3 days, and it was his intention to get it concluded in 3 days. And this particular witness was simply not going to answer questions in a way that allowed that to be facilitated. So the fact that the trial judge fusses at a particular witness in a case, this time being a party to the case, is not a basis for recusal under any of our case law. In fact, the case law and the cases that I quote from, that I just refer the court to on page 47 of our brief, make it clear that that's going to occur, and that sometimes trial judges are going to form opinions that they don't like a particular witness or a particular party during a trial based on the proof they've heard, and that's not a basis for recusal. None of that stands as a basis for recusal. And of course, the other reason, and I just want to point this out, because the other reason that it seems to me to have been incumbent on them to address issues of recusal early on was they slip into their brief, and occasionally prior to that in the record, the fact that my client was a practicing divorce lawyer in Williamson County, Tennessee. Now, it came out in the proof in the case when I examined her on a direct examination. She'd never tried a case, never tried a divorce case there. She did mostly collaborative law, and of course that means when cases break down in collaboration, then everybody has to withdraw, the lawyers do, and start with a fresh set of lawyers. I've never done one of those. Doesn't particularly appeal to me, but I'm kind of wired for conflict, I guess. But so she hadn't tried any cases in those courts. But even if she had, even if she were in there every day, both parties, every lawyer involved in the case, and all the trial judges in the case were aware of that fact from day one, from March of 2021. So if that were a basis for recusal, and it keeps being referenced in the filings, then that should have been addressed in March of 2021. It's not uncommon for trial judges in a judicial district to recuse themselves on cases in which lawyers are litigants. They're not required to. There's nothing in the canons or in the rules that require that to occur, and Judge Woodruff didn't see fit to do that in this case. And surely, after 2 years, when Judge Binkley got handed the case in March of 2023, we weren't going to, it was not incumbent on us to ask for that to occur. If anybody were going to do that, it would have to have been Mr. Didomenico. It would have been late at that juncture, I believe, but it didn't occur in any rate. So this is really a first for me, I'll have to tell you. As the court knows, I've handled a fair number of appeals in this court over the years, and when I was waiting for the brief of appellant in this matter, I expected to get a lengthy brief raising many issues, not the least of which, probably the primary issue of which would have had to do with the application of Section 406 of the parenting plan law in this case, and how it affected or governed the disposition of the child custody issue. But to my really shock and surprise, I got a brief that said, we think Judge Binkley fussed at us too much, and because of that, we think subjectively, that a party looking at it subjectively would conclude that he was biased in favor of the wife, and therefore he should have recused himself. And so I don't know how a reviewing court, under those circumstances, not having been in the courtroom on those days in June of 2023, could possibly know what Judge Binkley, I mean, you can read the record and see how much difficulty. An interesting tactic in this matter, and I think really, frankly, an inappropriate tactic, was the use of ellipses to selectively focus on Judge Binkley's comments without providing the context in which those comments were made, by providing the answers, sometimes smart alecky answers, by Mr. Didomenico to the court during these colloquies. And Judge Binkley was asking him one time, isn't it true that about 85–90% of the time, she's going to say this and you're going to say that? And he kind of tritely said, well, I'm not keeping up with it. I hadn't been keeping up with the percentages. Well, I'll have to say Judge Binkley handled that pretty calmly, much more calmly than some trial judges would have. But I'm out of time, it looks like. I've always enjoyed coming down here, but I always try to conclude my arguments with asking the court if there are any questions that I need to answer at this point, any matters that I need to address that I haven't. So,
I don't hear any, Mr. Manus.
thank you, Judge. Sure.
All right, thank you, Mr. Manus. Mr. Booton, your rebuttal, please.
Your Honors, the notion that none of the findings of fact and conclusions of law were challenged in this case, it reminds me of a story. And I've got 5 minutes, so I'm going to tell you this story very quickly. Several years ago, my brother invited extended family to his house for Thanksgiving, which was out of character for him. We said, okay, we'll go over there. We went to his house, we had good food, we had good company. At the end of the night, he brought out a cake that he had made, and we all ate the cake, and the cake was delicious, to his credit. As we're wrapping up the night, he says, oh yeah, funny story about the cake, by the way. He said, I was making the cake this afternoon, and I'm getting my ingredients out. I got my eggs, got my sugar, and I was getting the sugar out of the canister to put in the cake. And as I was going to close the lid on the canister, I looked in there. I don't know how it got in there, but there was a dead mouse in the canister with sugar. And he said, so I disposed of it and went along my way. And all of us at the dinner said, are you telling us that you made the cake with the sugar from that had the mouse in it? And he said, well, yeah, but what's the harm? Because you all said the cake was good and everybody loved the cake. What's the problem here? And all of us, to a man, even his wife, looked at him and said, are you crazy? You made the cake after knowing that the mouse was in there, after it had tainted the sugar, and you served it to us? And he said he still to this day doesn't think he did anything wrong. The response from us was the correct response. Not the fact that the cake was good or that we hadn't had any problems with the cake. It was the fact that he made the cake with a tainted ingredient. Once the ingredient was tainted, the end result doesn't matter. It doesn't matter that we all loved the cake. It doesn't matter that we all raved about the cake. The tainting was in the process. That's the same principle here. The findings of fact and conclusions of law at the end of this case, they don't matter. Because once the process was tainted by the actions and the behaviors of the trial court, nothing after that matters. Which is why there was not a brief done with all the findings of fact called into question and all the conclusions of law called into question. Because what we're challenging here, we're challenging the process. Once the process is tainted, nothing else after that matters. Even if the cake was good, it doesn't matter because we ate a cake that was made with tainted sugar from a dead mouse. Now, we don't go to my brother's house anymore for dinner. That's just a standing rule. Nobody goes over there anymore. But again, he's still steadfast in his resolution that he did nothing wrong because the cake ended up good. We don't care if the cake ended up good. The process was tainted. That principle is actually backed up by the Tennessee Supreme Court in Cook v. State, and it's mentioned in the reply brief. The finding of fact by the trial court is challenged, or was challenged on appeal. According to the Tennessee Supreme Court, this is immaterial. Because the post-conviction judge should have disqualified himself under the Rule of Judicial Conduct 2.11, the petitioner is entitled to a new hearing before a different judge on his petition. We express no opinion on the merits of the petitioner's underlying claims, as the evaluation of those claims must be made by the newly assigned judge based on the evidence presented at the new hearing. So it's our position that because the process was tainted, nothing else matters after that point. I know I've got a minute and a half left, but those are all my remarks.
And I don't hear any more questions. Thank you.
Thank you, Your Honor.
Thank you, Mr. Booton and Mr. Manus, for your arguments. We'll take this case under advisement.